Welcome once again to Lehto's Law. Here's Steve Lehto.
Whole bunch of people sent me this story about a situation in Los Angeles. And this is one where there's an attorney right now wishing social media didn't exist. From U.S. Times Post, judge throws out verdict after lawyer bragged about it. The judge threw the verdict out after the lawyer was seen bragging about it. And the Los Angeles Times, I believe, broke the story. So when his medical malpractice trial came to an end in April, a doctor won the case, and this was in Orange County Civil Court. Quickly and unanimously, the jurors ruled that the gastroenterologist was not responsible for the death of a patient. But then his attorney showed up in one online celebration video where he boasted about his work, saying the case involved, this is the quote, a guy who was probably killed through negligence, but we kind of made it look like other people did it. Citing those comments, the judge who'd heard the case overturned the verdict and remanded the case back to court. I think I have to protect the system and say that the plaintiffs deserve a new trial, the judge said at an August 4th hearing. The case involves a man who's 49 years old, a forklift operator, admitted to South Coast Global Medical Center in Santa Ana. He had severe abdominal pain from alcohol-induced pancreatitis. The doctor inserted a feeding tube that accidentally pierced the man's colon, resulting in a fatal infection, according to the lawsuit. The focus of the family's case was the death certificate, which attributed the death to sepsis and peritonitis from a perforated colon. The man's family was asking for $10 million, but in defense of the doctor, the attorney pointed to mistakes made by other people, the other hospital staff, and argued that the man died of other causes. He asked the jury to ignore the death certificate and ridiculed the personal injury industrial complex and claimed the lawsuit was a form of extortion. Shortly after winning the case, the attorney met with colleagues for an office party and invited a legal partner to ring the victory bell. A video of the boastful comments was posted on his company's social media page, but was removed shortly thereafter due to a backlash. The attorney apologized for what he called his imprecise remarks, saying they were intended solely as an internal briefing for our staff. He said he was not aware they would be made public. At a hearing to decide whether a new trial was warranted, the judge said he found the celebration video extremely important. If he says on video that a guy was probably negligently killed, that's more likely than not. Then he goes on to say, but we kind of made it look like other people did it, the judge said. It appears to be an admission of negligence. Meanwhile, the attorney for the victim's family said that the attorney inappropriately pointed the finger at other medical workers as culpable for the man's death, contrary to an agreement not to do so, but then later bragged about it. Well, boasting isn't much of an irregularity, the judge said. He's a lawyer. But here's the problem. Stating that justice has not been done disturbs the court. In deciding the plaintiffs deserve a new trial, the judge also noted a 3-week break he allowed during the trial that may have affected the jury's recall of information. He also said the jury foreman failed to mention in the jury's selection that he had worked as an insurance agent for 2 years, which in itself may have been enough to warrant a new trial. The judge said the attorney was an excellent attorney with a reputation for honesty and integrity, but good men make mistakes. So, noting that the victim was from El Salvador, the judge also expressed concern that the attorney used the phrase, "Welcome to America," in his closing arguments. Remember when he spoke about the personal injury machine, he shouted, "Welcome to America." I just think that can only be interpreted as an emotional appeal to invoke anti-Hispanic feelings. The judge said the jury, which had 26 minutes to reach, the judge said the jury, which took 26 minutes to reach a verdict, did not ask to see exhibits and apparently did not examine the evidence, saying its decision was the result of some emotion. Now, the attorney is from Huntington Beach and the founding partner of a law firm, did not respond to requests for comment on the situation. So it goes on a little bit from there. But the real point here is that there's a trial, a civil trial. And so the plaintiffs attorneys are asking a jury to find in favor of the plaintiff and award money for damages. And they say that these damages result from the malpractice of a doctor. The defense attorney who's defending the doctor says, no, if there's damages, they're the results of other people's negligence, and you shouldn't give any money to them from my guy. And these kinds of trials happen all the time. Medical malpractice cases happen all the time. But the weird part here is that the guy was seen on video saying a guy who was probably killed through negligence, but we kind of made it look like other people did it. And there's a couple other statements in there that appear troublesome. And generally speaking, if you simply had video of an attorney who says, I won the case, and there was a lot of stuff going the other way, that wouldn't necessarily do it. And in fact, if you think about this, people are more prone to brag about the difficult victories than the slam dunks. And so if somebody has a case where they're defending a frivolous claim and they get it thrown out or dismissed, or a jury comes back and no causes them, you can brag about that, but it's not the same as beating a difficult case. So I can see where the judge is saying, hey, look, people brag, especially lawyers, but the judge also pointed to some other things. And the question is whether the other side raised that or the judge did this, because if the defense in this matter appeals this and says, look, that first trial is all there should be, there shouldn't be another trial, and if they could only hang their hat on the judge saying he saw the videotape that the guy made after the trial, if that was the only basis for the new trial, there's a chance a court of appeals might say, how do we draw the line on this? What if the guy made the statement a year from now? What if he bragged about it 10 years from now? What level of bragging would it take? And I understand the guy's not just bragging here. He appears to be saying that liability may have gone elsewhere if the jury had actually thought about it. But the point is, the judge also said there were a couple other problems. A member of the jury who didn't disclose their past properly, that's problem number one. And the length of time they were out without examining anything suggests also that they may have been in a hurry. I've actually been on a case before, jury trial, where closing arguments start Friday morning and end at 3 o'clock Friday afternoon. And everyone knows that that jury's going to go back and say, if we can knock this out by 5 o'clock, we can all go home and never come back again. Or if we don't knock it up at 5 o'clock, we got to come back on Monday. Who wants to get this done now? Raise your hands. Okay, which way are we going to go? And that's what happens. It's sad, but these things happen. And those are the kinds of things that are hard to predict when it comes to jury trials. I can also tell you that I have seen attorneys, in the news by the way, bragging about how they've gotten away with things or made certain kinds of arguments. And I've often wondered if it ever comes back to haunt somebody. But I remember a case where a defense attorney was defending a guy who was seen running from the scene of something, and he had a backpack. And there was stuff in the backpack that was important to this story. And as the guy's running, he takes the backpack and he throws it. And so one officer stops and grabs the backpack. The other officer chases the guy down and grabs him. They come into court and they go, here's the backpack, here's the guy, here's what was in the backpack, and here's two cops who saw the guy toss the backpack, and here's the cop who grabbed the backpack, and blah, 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 blah. And I read an interview where the attorney was joking that he had nothing to go on. And so on cross-examination of both police officers, he said, did you guys ever do any DNA testing on the backpack? Any DNA testing to try to link it to my client? They go, we didn't need to do DNA testing. We saw your guy. He had it on him. He was running, and then he threw it in an attempt to get rid of it, and we just walked over and picked it up. That's his backpack. So you didn't DNA test it, did you? You didn't. And went to the jury, and that was his argument. Who knows whose backpack that is? They didn't even DNA test it. If they DNA tested it, we'd know. But they didn't DNA test it because, and of course the implication is that they were trying to hide something or they're cheap or something, when in reality, back then, DNA testing cost a fortune, and you can DNA test everything if you want to. Who's got that kind of money? And of course, the jury came back with not guilty. And the interview I read, the attorney was laughing about it. He goes, it's all I had. And interestingly, and I've had people ask me this, they go, Steve, if you're an attorney and you're representing a guilty person, you know he's guilty. Doesn't get on the stand and say he's guilty, but you know he's guilty. He's just sitting there, though, because Fifth Amendment. He can sit there, right to remain silent, doesn't say a word to anybody about anything. He's just sitting there. What right do you have as an attorney to defend him if you know he's guilty? Well, the rules on ethics specifically say that you, as an attorney, are allowed to force the prosecution to prove every element of a crime, regardless of whether you think your client's guilty or not, because your client's actually innocent until proven guilty. And so you can make them do their jobs, okay? But the question is, if you got nothing to work with, what are you going to work with? So, did you DNA test that backpack? No, we had witnesses who saw him wearing it. He starts running. Cops see him take it off and throw it. They grab it. That's his backpack. That's the one he had on him. But you didn't DNA test it, did you? So, interesting thing, though, of course, is that in a criminal case, if you get a not guilty, you can't retry him because that'd be double jeopardy. This is a civil case in the medical malpractice one. So it's an interesting verdict. It's an interesting outcome. I've never seen anything like this before. Never. So crazy case from the U.S. Times Post and Los Angeles Times. Judge throws out verdict after a lawyer bragged about it. Les, Gary, Ron, Mike, and Timothy all sent it. Thanks a lot. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. Remember, the more you expect things to be a certain way, the more disappointed you'll be. Accept life as it is. You'll be free.